All right, good afternoon, everybody. My name is Dr. Uzuazo Etemire, and this is the BIICL Nigeria National Conference on Corporate Climate Litigation. I believe everyone who is here must have seen the flyer, and we're just going to have a very important discussion today about corporate climate litigation in Nigeria under the auspices of the British Institute for International and Comparative Law. The discussion today will be based on a report or around a report that I wrote for the BIICL on corporate climate litigation in Nigeria. And for today, we'll have three key speakers who will be addressing three key aspects of this topic. But before then, we'll have Mr. Anthony Wenton, who is going to tell us about the general project on the global toolbox on corporate climate litigation, a program that has been running for more than a year now, and has finally come to fruition under the auspices of the BIICL. She'll tell us about that program generally, and then I'll talk a bit about the Nigerian report, and then we'll hear from the speakers for the day, starting with Dr. Ayodele Morocco-Clark, and then Dr. Ekhator and Dr. Okukpon. And then we'll have a period of question and answers, if there are any, and we will have the session of the conference wrapped up by Mr. Ivano, who is the leader of this particular project from the BIICL standpoint. So I'll just hand over to Mr. Anthony Wenton, who will tell us about the general global corporate climate litigation project that has been run by BIICL. Thank you.
Hey, thank you very much. So good afternoon. It is afternoon now, I think, just about, everybody. Thank you very much for attending. I'm a research fellow at the British Institute of International and Comparative Law and a member of the team working on BIICL's project on global perspectives on corporate climate legal tactics. Before we move on to the main speakers, I'm just going to briefly introduce the project. But before that even, I must say thank you very much again to Dr. Etemire and the other expert contributors for the excellent report he prepared on a very wide range of causes of action, procedural and evidential issues, and remedies that might arise in the context of corporate climate litigation in Nigeria. And his description of these complex topics was written with such clarity that it's really a pleasure to read, and it's made it so much easier for us to compare what's going on in Nigeria with 16 other jurisdictions we've studied so far. So thank you very much again. So I'll begin with a few words about the origins of our project. So as we know very well, there remains an enormous gap between the action needed to combat climate change and to achieve the goals of the Paris Agreement and the migration and adaptation measures that are actually being implemented by states. And the Intergovernmental Panel on Climate Change is absolutely unequivocal in stating that instead of reducing, the greenhouse gas emissions actually continue to increase, intensifying extreme weather events such as floods, droughts, and heat waves, and harmful consequences, including the melting of glaciers, sea level rise, and forest fires. And indeed, in 2022, around the time that we were getting our project off the ground, the UN Secretary General stated in very stark terms that we're in the fight of our lives and we're losing. The greenhouse gas emissions keep growing, global temperatures keep rising, and our planet is fast approaching tipping points that will make climate chaos irreversible. And as he said, we're on a highway to climate hell with our foot still on the accelerator. So our project is considering what mechanisms do we have at our disposal to try to take our foot off the accelerator. And in response to the failure by governments and the international community to take all the steps required, a wide range of actors, from children and youth to pensioners and NGOs, indigenous groups, civil society organizations, have increasingly begun to turn to litigation to compel climate action and to seek compensation for climate-related harms. Thus far, governments have been the most common defendants, and there's been much useful research on how to use citizen climate litigation as a way to ask courts to require governments to reduce emissions and take other measures to reduce climate-related impacts. And particularly noteworthy in this regard is the International Bar Association's report and model statute for proceedings challenging government failure to act on climate change. However, there's been much less analysis of the potential for climate litigation involving corporations. And this is where our project, led by Dr. Ivano Alonia, comes in. So the heart of our project is what we call the Corporate Climate Litigation Toolbox. And what we've done is to conduct independent comparative analysis of court cases and legislative provisions in legal systems around the world. 17 so far, but we plan to expand this significantly in the coming years. And we've done this analysis in order to identify arguments, procedural mechanisms, causes of action, and remedies that could be applied in corporate climate litigation in different countries. And the hope is that we'll provide a broad spectrum of stakeholders, from NGOs to legal professionals, policymakers, judges, and others. We'll provide them with the toolkit they need to quickly access the lessons and precedents that can be taken from other countries and other types of litigation that will help them to achieve speedier, more efficient, more effective, and more predictable corporate climate litigation. So I will conclude with just a few slides to show you our website. Okay, so as you see there, the Toolbox forms part of a larger corporate climate litigation platform, and this contains a corporate climate litigation resources section. This is a repository of the latest literature in the field of corporate climate litigation. I'll show you that page very briefly. So you see here we have books, journal articles, research reports, but also webinars and podcasts and blogs. So we have the very cutting edge of thinking in this area. Then the next part that we have is the Corporate Climate Litigation Database. This is not online yet. This is up and coming, but this database will be powered by artificial intelligence. And so it will allow stakeholders to immediately access the resources and the precedents that they need. So, for example, if you are concerned with litigation based on the right to life or right to a healthy environment, you will be able to instantly pull up all of the information, precedents, case law that you need on that area. And then the biggest part of the platform is, as already described, our corporate climate litigation toolbox. So in here we have the national reports that have been prepared by our rapporteurs, such as Uzuazo. We have 17 countries we've looked at in detail so far. We hope to double this in coming years. And then, as well as that, we have, so you can see the national reports to get into detail on each of those 17 countries. Then you can also access our toolbox, where we have our comparative analysis of the various tools that we've identified from each of these countries that we hope can be used in other countries, and we can learn from each other. Turning to the future, we are going to have 17 national conferences, including this one today, So that's one for each of the case study countries we've studied so far. And we'll also have 5 regional summits, which will bring together stakeholders from across each continent. And we will disseminate the Toolbox research, and also we take feedback in order to improve the Toolbox and further expand upon it. So I will leave it there and hand over to Uzuazo. And thank you very much again.
Yeah, thank you very much. Thank you very much, Anthony. So I'm just going to say a few words about the Nigerian report that I wrote for the BIICL, on the basis of which we are having this particular session today. I would just like to share at least the front page of the report. Let me see if I can do that. Okay. Yeah, so that's the report that I wrote for the BIICL on corporate climate litigation in Nigeria. I believe it's one of the, of course, it's a fast-moving field, one of the most updated reports on the state of the art in this field in Nigeria. It talks about the fact that, for example, Nigeria is the most populous country in Africa. It has, at least till now, the largest economy in Africa. That may change very soon. And all this is being fed by its oil and gas industry, which is also the major source of greenhouse gas emissions in Nigeria. And so the report really takes a perspective that mainly focuses on greenhouse gas emissions from the oil and gas industry, particularly gas flaring. References are made to some other sources of greenhouse gas emissions in Nigeria, but the dominant one that this report focuses on is on greenhouse gas emission. And the aim of the report was to analyze systematically, as best as possible, how the emerging mechanism of corporate climate litigation can be useful in helping Nigeria to reduce its greenhouse gas emissions and its contribution to climate change globally, even though it has a small percentage in terms of contribution to global climate change. But then in Africa, it's the second major contributor, and I think the 25th major greenhouse gas emitter across the globe. So it's still, in the wider scale of things, it still has a share in that particular contribution. And this report discusses how we can use corporate climate litigation to help to reduce its own contribution to global climate change. The report takes the report is divided into 3 parts. It analyzes the subject from 3 parts, particularly from the aspect of causes of action. It looks at evidence and procedures in the courts, and it looks at available remedies for actually addressing climate wrong in Nigeria. In summary, the report concludes by saying, in summary, that Nigeria has had few successes when it comes to corporate climate litigation. And then it has presently some measures which have recently emerged, such as the recent Company and Allied Matters Act 2020 and also the Climate Change Act 2021, that provides an ecosystem that may be convenient for climate change litigation proper in Nigeria. And then it talks about the challenges of the hurdles in terms of evidence and procedure or respect to certain types of causes of actions in Nigeria that may not be too convenient or comfortable for promoting corporate climate litigation in Nigeria. So in summary, it talks about successes, potentials, and also the hurdles to corporate climate litigation in Nigeria. So it's around these 3 themes that the 3 speakers will be educating us today, starting first with Dr. Ayodele Morocco-Clark. She's an associate professor in Nile University, Abuja. And next she'll be talking on causes of action. And then we will have Dr. Eghosa Ekhator from the University of Derby, United Kingdom. He'll be talking about evidence and procedure. And lastly, we'll have Dr. Irekpitan Okukpon from also University in the UK. She'll be talking about remedies, the adequacy or not of remedies when it comes to climate change litigation in Nigeria, looking at the present state of the law with respect to these themes and what we should look forward to, or the way forward, as the case may be. So first, I'll start by introducing Dr. Ayodele Morocco-Clark to take us on causes of action on this subject.
Okay. Good afternoon, everybody. Thanks for joining us. As Dr. Etemire has said, my name is Ayodele Morocco-Clark from Nile University of Nigeria. I'm dealing with the causes of action and routes towards climate action, climate litigation, particularly focusing on Nigeria. I would like to share some slides. So I'll use them. I know I have 15 minutes. I hope I can finish within that time, but I'll try my best. Just a minute. Can you all see my slide?
Yes.
Yes?
Yes.
Okay,
yes.
yes.
We can.
Yes. Yes.
This is what I'm talking on, climate action in Nigeria. So I'll just go down I think just a minute. There's something blocking. Yeah, my way down. Cool. So I'm talking about the key causes and routes of action. Now, I'm going to address my presentation or my talk today from a two-pronged angle. Now, looking at the key causes and routes, we are going to take the domestic angle, that's dealing with climate litigation within Nigeria, the causes of action and routes that you can take to get through or to access climate justice here in Nigeria. Then we'll look at it from the international angle, look at a few treaties, international agreements, and what various international courts, a few courts have said with regards to climate change and the rights therein. Now, on the domestic angle here in Nigeria, if you want to go to court, you have a grievance regarding climate change and your rights, especially human rights, but not restricted to human rights. We have various routes. You can come via common law. We can come via the various statutes we have in Nigeria and the regulations and policies that come thereunder. And then we'll look at case law because those provide judicial precedents. Now, under common law, predominantly, climate action can be instituted under the law of torts. And there are four principal heads. It's not restricted to them, but these are the four that would normally ground an action in climate litigation. The first is trespass to land. The second is nuisance. The third is negligence. And then we've got strict liability. That's the rule in Rylands and Fletcher. Now, trespass to land, here, the plaintiff or the claimant who is aggrieved is talking about unauthorized access to his or her property. And trespass to land as a tort is actionable per se, which means that the complainant does not need to prove particular damage. It just has to show that there has been a trespass, an unauthorized entry or access to his or her land, and that would ground a basis for this particular action, and if necessary, the award of damage. Now, in Nigeria, generally, I will say this over and over as I go through, we've not had really specific climate litigation here, but we've got cases that impact and allude to the climate and climate change and how it affects us. And I will go over those later. But here, because it's climate litigation and climate action is in its infancy here, this is one of the routes that could be utilized. However, the success or failure of bringing the suit here will depend on the willingness of the courts to expand the scope of trespass to land so that it moves past just physical aspects onto remote or intangible access. So normally you think, oh, somebody has to enter your land for this to ground an action in trespass, but the jurisdictions like Canada, there have been decisions that say that it doesn't necessarily need to be so. Like smoke or fumes coming from some other property onto yours could be a basis for an action in trespass. Then the next head is nuisance. Now, nuisance has two angles under it. We've got the public nuisance and we've got private nuisance. Now, the public nuisance is an inconvenience or interference that relates to public at large or a section of the public. And under public nuisance, it's usually the Attorney General that is empowered to bring an action for public nuisance. However, with the decision of the Supreme Court in Center for Oil Pollution Watch and the Nigerian National Petroleum Corporation, it's clear that nobody has to wait for an Attorney General to bring an action. NGOs, public spirited individuals, and private individuals, anybody can do that if the climate is under threat or you have actions that are impacting on the climate. So what it is here is that in Nigeria, anybody who knows about Nigeria, for those of us who are in Nigeria, we understand that litigation is never really easy. So if there is an issue, for example, Nigeria, of course, we are the largest flarer of gas on the African continent. And right now, you find out that no Attorney General, especially the Federal Attorney General, has decided to institute an action saying that this was stopped because the various legislation say gas flaring really should be outlawed and should only be carried out under some certain circumstances. So because the federal government, of course, receives quite a lot of income from the petroleum industry, it's unlikely that the Attorney General of the Federation will be there to stop the oil companies operating if they do not comply with these gas flaring provisions and stopping them. And of course, we know the gas flaring contributes to the greenhouse gas emissions in the country. So it is hoped that maybe some state attorney generals might decide to pick up the mantle and do that. But if not, of course, any public spirited individual, NGO, and all can go ahead to institute this. A private nuisance relates to the interference with private enjoyment of property rights. And under this, you find that it's going to be harder to ground an action in private nuisance. However, of course, if you can prove it, like an individual solely can prove that he or she has been affected as a result of greenhouse gas emissions or fumes that are affecting the environment and the climate, they can bring an action for that. But because of the way it is with things like smoke and well, with the air, normally it would not be one person. Now that's why it's a bit harder with private nuisance. However, climate action can come forward, and I would talk about it later. If you look at things like oil spills, and because a lot of people don't think of oil spills and climate change, but the truth of the matter is that oil spills have an impact on the ecosystem, on the biodiversity, which in fact affects the climate, because these we have natural carbon sinks that are in various ecosystems on land, underwater, and with the spillage of oil, it's one of those things that modifies and destroys a lot of these ecosystems, meaning that the balancing of the emission, the oxygen and carbon, so would not work in a way that, since the organisms that would normally have pretty much neutralized a lot of these greenhouse gas emissions and a lot of carbon dioxide are not able to do so due to their habitats being destroyed or impaired, this would be a problem, and this could affect the climate. And so there could be an action under private nuisance, especially if it's your land that has been affected. If you have a private pond, you have streams and things like that. So private individuals can do that. The third head under tort is negligence. Negligence here is based on three major pillars. There has to be a duty of care. So the person who is making the complaint will say whoever the defendant is owed him a duty of care. There has to be a breach of that duty of care, and that breach must have resulted in damage. But apart from these three pillars, in order to successfully found an action, you have to also prove that there has been causation between that action complained about and the damage suffered. So it must not be something that is independent. There must also be, it must not also be a situation in which it's going to be far-fetched. There's what is called the reasonable foreseeability rule. So it must have been reasonably foreseeable that a person acting in this way should know that his actions or her actions result in this kind of repercussions. So once that is proven, then a person can successfully have a cause of action in negligence before the courts. The last tort I will be talking about here is strict liability. That's the rule in Rylands and Fletcher, which talks about a person who brings in something unnatural to his land or under his control, and that thing escapes and causes damage. In that situation, that person is liable for the damage. Now, a lot of people think that the rule in Rylands and Fletcher might not necessarily found or ground climate action. But like I said, with the oil spills and all, and the destruction of the ecosystems, you find that the UN and researchers have agreed that ecosystems and the biodiversity they contain natural carbon sinks, providing nature-based solutions to climate change. And once this happens, because of the oil spills, this would result in, of course, disastrous consequences for the environment, and has been doing so in Nigeria for about 6 decades now. So you find out that even of course, biodiversity is the diversity of plant and animal life. So you find that there are lots of species that have been lost, and even wetlands and mangroves have been lost. And so this, of course, has a negative impact on the environment. So strict liability is an avenue that can be explored when you're talking about climate action, climate litigation. Now, moving on further to the next bar, that is the legislation, regulations, and policies. The first and the highest legislation or law is, of course, the Constitution of the Federal Republic of Nigeria. Now, Section 20 of the Constitution mandates the government to protect and improve the environment and safeguard the water, air, forest, and wildlife. Now, a lot of people will argue that Section 20 comes under Chapter 2, and so is non-justiciable as a result of Section 6(c) of the same Constitution. However, in the Center for Oil Pollution Watch and NNPC, Nigerian National Petroleum Corporation case. The Supreme Court has said it, and it's something that is clear that there are, of course, instances where things under Chapter 2 of the Constitution, of which Section 20 is a part, can be justiciable. It can be justiciable if it's mentioned somewhere else in the Constitution, can be justiciable if the National Assembly has passed a law regarding that same subject matter. And with regards to the protection of the environment, there are various laws in Nigeria. Now, we have the Climate Change Act, we have the Petroleum Industry Act, both of them are 2021. Then we have the Environmental Impact Assessment Act, it's the 1992 Act, so it's Cap E12, Laws of the Federation of Nigeria 2004. We also have the National Oil Spill Detection and Response Agency Act. And like I've said before, because of the thing of oil spill, when people are thinking of climate, they don't think of oil spill. But the NOSDRIA Act is important. That's the National Oil Spill Detection and Response Agency Act is important because the NOSDRIA, the agency, that is the National Oil Spill Detection and Response Agency, is the agency that is empowered and saddled with the responsibility of the regulation of the petroleum industry in Nigeria. And also, like I've said, and what I said about the UN and the researchers, oil spills destroy and threaten biodiversity, and this negatively impacts on the environment and the climate. So the NOSDRIA Act is very important. Then we also have the African Charter on Human and People's Rights, the Ratification and Enforcement Act, Cap A9 LFN, Laws of the Federation of Nigeria 2004. Then under that, we have some regulations which I've also included. This includes the Midstream Gas Flare Regulations 2023, and this was issued by the Nigeria Midstream and Downstream Petroleum Regulatory Authority, pursuant to powers under the Petroleum Industry Act. And we have the Gas Flaring, Venting, and Methane Emissions, Prevention of Waste and Methane Emissions Regulations 2003. And this was issued by the Nigerian Upstream Petroleum Regulatory Commission. Now, and this particular regulation repealed the Flare Gas Prevention of Waste and Pollution Regulation of 2018. Now, the Climate Change Act is an act that was put there to deal with Nigeria's obligations under its international treaties and conventions. Now, principally the Paris Agreement. And it's talking about ways in which Nigeria can seek to regulate and minimize emissions of greenhouse gas the emissions of greenhouse gases. The Petroleum Industry Act is also relevant here because, of course, the petroleum industry is very integral to Nigeria's survival and all, and it's necessary to look at the provisions, but also within it, there are provisions regarding the stopping of flaring of gas, but of course, also the general conduct of the petroleum industry. The EIA Act, that's the Environmental Impact Assessment Act, is very important because that act is it's mandatory to follow, but unfortunately has not been followed diligently by the government, by various companies, multinational companies, and even Nigerian companies and players in the industry, the regulators as well. The relevance of this EIA Act is that any project which is likely to have an adverse effect on the environment has to have an environmental impact assessment done to see what these effects will be. And if it is such that the effects are going to be devastating to the environment, then it wouldn't go ahead, or it could go ahead with some modification, or sometimes the modification can be modification of the project itself, or maybe the siting of the project and all. I will talk about the Bahrain disaster in Bayelsa State, I think it is, wherein there was a lot of mangrove land that was lost as a result of improper EIA being conducted. So that's that. So I'll move on to that because I think my time will soon be up. I probably have less than 5 minutes. Now, despite various laws, regulations, and policies outlawing gas flaring, the flaring of gas continues actively. in Nigeria till today. Now, gas flaring has been outlawed in Nigeria since the 1st of January 1984, which is over 40 years ago. Under the now repealed Associated Gas Reinjection Act and its associated gas reinjection continued flaring of gas regulations. Now, even under the PIA, that's the Petroleum Industry Act of 2021, gas flaring is abolished on that by virtue of Section 104. However, under the old Associated Gas Reinjection Act and even the Petroleum Industry Act via Section 107 of the Petroleum Industry Act, gas flaring can be continued if the authority, or in the old case, the minister allows it by giving special dispensation. And that is the loophole which is still being exploited till today. Now, with these things, you see over the years, it seems like, oh, people are saying, oh, Nigeria is reducing its gas flaring, and that was not necessarily true. There was some time that the production of oil dropped for various reasons. Data and statistics provided by the National Oil Spill Detection and Response Agency, NOSDRA, in 2003, that was last year, showed that gas flaring increased by 10% to 138.7 million metric standard cubic feet for the period of January to June 2023, so it increased to 138 from 126.1 million standard cubic feet for the corresponding period in 2022. And in its gas flare report for the year, the NOSDRA disclosed that volume of gas flared in 2023 was 27.3% higher. That's the whole of 2023 this time, not just the half year, than the volume flared in 2022. As oil and gas companies operating in the country burned 205.2 billion standard cubic feet of gas in 2023. So it is clear that despite the extant laws and regulations, the provisions stopping gas flaring and reducing it are not being adhered to rigorously. And this, of course, can form a basis for climate action. Now, I'll move on to case law. Like I said before, there had not been any suit specifically and directly instituted in Nigeria, which the gravamen of the action is climate change. However, there have been a number of cases brought by aggrieved litigants that impact and deal with climate change. And a few of them, I mean, as far back as in the 70s, we have Chinda and Shell Petroleum, wherein the plaintiff instituted an action for the gas and noise and smoke that comes out of the flares of Shell. Now, the action did not succeed because it was brought under negligence, and the court had held that the plaintiff had not proven that the defendant was negligent. But you see, by that kind of action, it's one of those that has an impact on climate change. The same thing, Oronto Douglas and Shell Petroleum. This one, Douglas brought an action for the failure of Shell and with regards to the Nigeria Liquefied Natural Gas Project, that they did not perform an EIA, an environmental impact assessment, and the court pretty much struck out the suit for want of local standing. But on appeal, it was held that the court wrongly did that. However, this case was not reinstituted because the project had already been completed. So they didn't follow the law, they didn't do the EIA, and the project was to do with natural gas. So it was one that would have affected the climate. Bemre and Shell Petroleum, the same thing. Bemre brought an action wanting the oil companies in his community to stop flaring gas. And the court ordered that gas flaring in his community must stop, and declared that gas flaring in Nigeria is illegal and it violated the plaintiff's right to life and dignity. Shell appealed. The appeal had not gone forward, but I hear it has been reinstituted again a year or so ago. Ikechukwu Okpara and 3 others and Shell. This is the same thing about gas flaring in the community. So all these are basis for climate action, but although they did not allege or did not say, oh, we are suing on behalf, we are suing because of climate change and its effects on us, but for their own benefits due to the harm and damage they have suffered from gas flaring. Now, the Center for Oil Pollution Watch and the Nigerian National Petroleum Corporation is one I have talked about earlier. That one was they brought the action with regards to an oil spill, and there were some issues regarding local standing. But this is the first case, to my knowledge, that the court actually mentioned, although it wasn't a climate thing, but climate change was mentioned when talking about defending the climate. And the court in this COPW and NNPC expressly said that the right to a healthy environment is a fundamental right, and tied it to the right to life. So this case has taken Nigeria forward in leaps and bounds. Sorry.
If you can start writing, please. Yeah, thank you.
Okay. Just give me 2 minutes. I'll finish. On the international angle, we have various agreements. We have the Paris Agreement of 2015. Nigeria has ratified. We have the African Charter on Human and People's Rights, which of course Nigeria has also ratified. We've domesticated that one. And then we have the African Charter on the Rights and Welfare of the Child. And so all these are agreements that Nigeria is bound to comply with. Under the Paris Agreement, we have our nationally determined contributions, commitments, which we are supposed to stick to reduce our greenhouse gases and get to net zero by 2060. I'll just go quickly on to the next. So with these kind of things, also on the international level, there are different ways that climate action can be brought, especially if in Nigeria, it seems like everything is slow and justice is slow in coming. Now, you can use the extraterritorial jurisdiction side through parent subsidiary liability for people who are complaining of breach of their climate rights here in Nigeria to go to another territory where the parent company is founded to institute an action. And so recently also you see in cases like La Oroya and Peru that the court there had stated that, look, the right to a healthy environment is sacrosanct, and so environmental degradation can cause irreparable damage to human beings, and which is why a healthy environment is a fundamental right for the existence of humanity. And the same thing, there was a case a few weeks ago, Viren, Clemens, Signoren, Schwartz, and others against Switzerland, where the senior female citizens have brought an action that Switzerland was not doing enough for climate change. So with all these, and of course, we've had the decision in The Hague by a district court that ordered Shell to reduce its worldwide emissions, and this includes Nigeria. So this can be basis for climate action. So the trends shown in these cases mean that Nigeria can also be taken out of Nigeria to like any international court, and well, let's call it the African court, not any, but I'm sure when it comes to universal declaration and things like that, you could try. But here we can go to the African Court of Justice and Human Rights for breach of human rights, the climate abuse, and to found climate litigation. This can be done because we have the African Charter, we have the child one, and so this is an avenue for climate action. So I thank you. So for a comprehensive report, Dr. Etemire has told you about it. His report is titled Global Perspectives on Corporate Climate Tactics, Nigerian National Report. It can be found on the link there. If you guys want the slide, I'll provide it to them to give to you guys. And that is all. Thank you very much.
Yeah, thank you very much, Doc. Thank you very, very much for your interesting presentation. Thank you very much. Yes, we'll get the slides and share it with those who are attending or those who are interested. Thank you very, very much. So you stick around, please. Questions will be coming at the end of the day for you. So our next presenter will be Dr. Eghosa Ekhator from the University of Derby, UK. He'll be talking about evidence and procedures as it relates to corporate climate litigation in Nigeria. He'll be reflecting on that theme. Yeah, please, Dr. Eghosa.
Okay, thank you very much. I'll just see if I can share my. I've got slides as well. Let's see. Okay. Can you see my slides, please? So can you see my slides?
Yes.
Okay. All right. Thank you very much. Thank you for the opportunity to have a look at the reports. I was one of the people that gave feedback on the report. It was a very well-researched report, and I think the Institute and Uzuazo and other national rapporteurs, they've actually made a massive impact on this the scholarship on climate litigation. So my theme, which I'm discussing, talks about procedure and evidence in relation to climate litigation in Nigeria. So I've just got a few slides. I'll just run through what I'm going to discuss. So in the context of what we are discussing in terms of procedure, so the key thing for me when I was reading the report was local standards. So from what Dr. Ayodele has said as well, she made some allusions to the CPWK. So my question is, do we still have a problem of local standard? Have we actually resolved the local standard issue? Yes, we know that under the CPOW case, local standard in terms of environmental NGOs has been liberalized, and the Nigerian Supreme Court in that case said that potentially right to environment can be justiciable. But there is this sort of new argument which is recently developing, and if you guys have the time, you can read this paper by Poncheno Kole and Etisang Abraham in Search of Sustainable Future, a comparative assessment of climate change regimes in Nigeria and Kenya. It's a very interesting piece of paper. So the idea is that they're saying that some scholars are now arguing that the Nigerian Climate Change Act actually restricts local standard. That to me, that's going to be one of the biggest challenges potentially that we might face in having climate mitigation. Yes, personally, I believe that the Climate Change Act in Nigeria provides for climate mitigation. But the next question is, who are the people that can actually sue under this Climate Change Act? Yes, the Center for Air Pollution case has broadened climate has broadened local standard generally, but under the basis of the Climate Change Act, what is the remit of local standards? So, for example, Coley and Abraham argues that the Climate Change Act restricts the legal standing of relevant stakeholders that can sue public and private parties for the prevention of damage detrimental to the climate. So the idea is that the Nigerian Climate Change Act actually restricts the legal standing that you have to, on the basis of Section 34 of the Nigerian Climate Change Act, the victims have to be directly impacted by acts that are detrimental to the environment before they can get compensation under this law. Whereas under the Center for Air Pollution case, potentially everybody can actually institute cases in terms of environmental protection. So there appears to be a disparity between what the Climate Change Act is saying and what the Center for Air Pollution case has actually decided. So my view is that no matter the criticisms, Section 34 under relevant provision of Nigerian Climate Change that promotes climate mitigation, which improves public participation. But I think a major challenge is in terms of the local standard. Where is the in terms we are going to sue MNCs or corporate firms or engage in corporate litigation from Nigerian context? Who has the local standard to institute those cases? Can NGOs sue under this Nigerian Climate Change Act? I think there's a lot of potential, there's a lot of challenges around the Nigerian Climate Change Act. A lot of people have said that the Climate Change Act needs to be needs to be amended, needs to be revised because of some of these issues. So I think, personally, I think the issue of local standard under the Nigerian Climate Change Act is still not very clear. There's still a massive issue around that. Then the second challenge for me is funding. How do we fund climate mitigation cases? It's very expensive to get. For many of us doing environmental law research in Nigeria, many of the cases that we've read, we see the problem of trying to get experts, witnesses, trying to get scientific experts. It costs a lot of money, for example. So if a village or an oil producing community is going to sue an MNC, how would they fund this litigation? How would they get the resources to fund? I think for me, a major challenge is the funding. In terms of funding this case, is an access to justice, notwithstanding this development of this Climate Change Act, the various energy transitions policies that the Nigerian government has developed, this move towards energy transitions, access to justice still remains a very, very massive issue. So there are still institutional barriers against people getting access to justice. One, in terms of the delay in litigation, in terms of the power imbalance between the communities and the MNCs. So, and how many cases do we actually have now in terms of climate litigation? Yeah, talk about climate litigation, but the cases are virtually zero. So we try to ascribe a climate change status to existing environmental justice cases. That is what we tend to do in terms of our research. So there are very, very few cases in terms of climate litigation from a Nigerian perspective. And also, to me, in terms of procedure, yes, it's a major issue, but what about the lack of awareness of the climate change laws? How many legal practitioners in Nigeria, how many environmental lawyers in Nigeria actually are aware of the Center for Air Pollution case? How many lawyers actually are aware of the implication of the Climate Change Act? So the Climate Change Act was enacted in 2021. To my knowledge, I'm not sure there's been any case on climate litigation, Climate Change Act that have been instituted by stakeholders in Nigeria. So I think from my perspective, there's a lack of awareness of the utility of the climate change laws in Nigeria as well. So now, the other issues that, we talked about the impact of the Center for Air Pollution case. Let's remember the allusion by the Nigerian Supreme Court to right to environment discussion in that case was actually made obita. It was not, that right to environment was not directly in front of the court. The main issues was the local standard for environmental NGO to sue on behalf of a community that was negatively impacted by oil spill. So the question is, yes, Nigerian Supreme Court said right to environment can be justiciable and enforceable, which is the argument many of us have made for a very, very long time. But the question, the other issue is, what if a different panel of the Nigerian Supreme Court wakes up tomorrow and says that and restricts local standard from that was alluded to in the Center for Air Pollution? Because I think that's there's a possibility that a different panel of the Nigerian Supreme Court can actually restrict the import of the development in the Center for Air Pollution case. Because one of the major reasons, that's what I've always argued, that why that case, Center for Air Pollution case, was very pro-environment was because the late Justice Uwenze, it was an academic, was a professor, wrote the lead judgment. And if anybody has read that judgment reads like a journal article. Late Professor Uwenze, Justice Uwenze, Justice of the Nigerian Supreme Court, wrote a lot of papers on right to environment, has actually argued that right to environment can be justiciable in Nigeria. And that was evident in that lead judgment that they wrote in that Center for Air Pollution case. So what if you have another judge who's a bit not really pro-environment? So what is the guarantee that the Center for Air Pollution case will still be the main law in that regard in the next few years? Also, delay tactics by MNCs. MNCs are known for delaying litigation. MNCs are known for using technical issues to delay litigation. So that is still going to continue. And for a lot of people, we are aware that you should also know that climate litigation can also be used by the MNCs against NGOs, against people, against individuals. So climate litigation is not just a tool that the victims of climate change can actually utilize. On the other side, MNCs can actually rely on litigation as a way to restrict or to engage in in quotes, energy, climate change causing activities. So now in different parts of the world, even at the investment tribunal level, we could see a lot of cases currently that there's been a rise of counter litigation or counter claims being made by MNCs against some relevant stakeholders who regularly institute climate change cases, including NGOs, states, and communities. Now, so there's now, some people have said there's now like a regulatory chill in a way that even many countries are scared in terms of engaging in activities that reduce negative impact of climate change, because a lot of people could say that, some MNCs could say that that's against their contractual agreement, that's against their contractor clauses, etc. So the question is, from a Nigeria context, what is the guarantee in the next few years that MNCs will not be relying on litigation to restrict communities? So I think in that regard, that is also something we need to look at in terms of the challenge in that regard. MNCs can also rely or engage in counter climate litigation. So what do we do? How should we ensure and mitigate these challenges that we find in the climate change regulatory framework from a Nigerian perspective? One, we need to enact the Center for Air Pollution into law. So yes, the Nigerian Supreme Court has said local standard is for everybody. The environment is a public good, and everyone can protect the environment. So that's actually opened up environmental litigation to anyone and everybody, to potentially everyone in Nigeria. So from that perspective, my sort of recommendation is that the Center for Air Pollution case should be enacted into law to guarantee that maybe tomorrow a different panel of the Nigerian Supreme Court will not say a different, will not provide a different interpretation, will not restrict the local standard in terms of arising from that case. So should enact, the National Assembly should enact legislation that actually puts in writing that local standard is open for every environmental NGO. Individuals can basically sue MNCs or government officials and bodies in terms of environmental and climate mitigation. I think that is one way to go. Then also, Uzuazo also mentioned this in his report as well, in terms of climate change awareness. There has to be a massive climate change awareness in the country. In one of my recent papers, which I've just done, that talks about international biodiversity conventions, the use of environmental education to implement biodiversity convention. We can also embed climate change education into awareness into our legal education curricula, into our university curricula. So now in a lot of universities in Nigeria, to my knowledge, I don't think climate change education awareness is a key part of environmental law courses in Nigerian universities. From what I've found so far, I don't think the Nigerian law school actually embeds or integrates climate change education awareness into the legal curricula at Nigerian law school. So now, any Nigerian lawyer or any lawyer in this area needs to be aware of climate change. So climate change awareness needs to be integrated, needs to be embedded into the Nigerian legal curricula. So finally, we also start thinking of the use of regional and sub-regional mechanisms, including courts such as the African Committee of Experts on Rights and Welfare of the Child. I know Dr. Ayodele alluded to the potential of a sub-regional court. Yes, up to now, I know there's not been any sort of explicit climate litigation case from many of the regional courts or sub-regional courts, but I know that the African Commission is actually they're actually developing. There's a recommendation that will soon be in the public regarding climate mitigation. So there's a potential for regional and sub-regional mechanisms. So this is my recommendation. So I think, yes, we have climate mitigation. There's a potential for climate mitigation in Nigeria, but we also need to engage with the Climate Change Act, and lawyers, activists need to ensure that the Climate Change Act is interpreted with the modern reality, and the Climate Change Act should not be an obstacle to climate mitigation, because if we take the view that the Climate Change Act restricts local standard, then we have a massive problem in terms of procedure and evidence from a Nigerian context. Thank you. That's the end of my presentation.
Yeah, thank you very much, Dr. Eghosa. Thank you very much for a very incisive presentation. And you have raised very fundamental issues, including the matter of awareness raising about most of the progress and the hurdles and the issues surrounding climate litigation in Nigeria. I think that's one reason why we took our time to invite people from relevant NGOs and also legal practitioners to join us in this discussion as a way of disseminating information. And I can see some of them as participants, and I would like to thank them for honoring the invitation. Thank you very, very much. So that's a big issue, dissemination of climate change information. I think in the recent revised National Environmental Policy in Nigeria 2021 or 2019, it actually made that recommendation that studies on climate change should be mainstreamed into curriculum of various courses in Nigeria. And I think that's one important aspect that has to be implemented. We talked about the need to solidify some of the obiter judgments of the Supreme Court as regards the right to environment and how it can benefit climate litigation. That's a very good one, yeah, because if it's transported into legislation, of course, it makes it more solid, as it were, because you have expressed fears about another panel of Supreme Court judges may arise that may take a different stance on some of these issues in a case that that may give ratios proper judgment on them that may differ from what we have on ground. Thank you very much for the. We'll come back to you with some questions on some of the issues you have raised, but for now, we'll just move over to Dr. Irekpitan Okukpon, who will talk about remedies in corporate climate litigation in Nigeria. Yeah, thank you very much, Dr. Okukpon. You have the stage now.
Thank you very much, Dr. Etemire. And I would first of all like to thank our participants for being here on this very interesting topic. I would first of all like to commend Dr. Etemire and his team of people who worked with him on this Nigeria National Report. For our participants, if you haven't already noticed, Ivana has put the link to other country reports for your attention. So it's important for you to see what's obtained even outside Nigeria and in other countries. My fellow discussants, Dr. Morocco-Clark and Dr. Ekhator, have raised really excellent views relating to climate litigation in Nigeria. And so in my discussion, and also being quite conscious of time, I'm going to start my discussion with the European Convention on Human Rights and end with the position on the European Convention of Human Rights as a means to discuss what exactly is happening in terms of remedies in Nigeria and what we need to do. I found really interesting that Article 13 of the European Convention on Human Rights 1950 has something called the right to an effective remedy. And what that means is that litigants who feel that any of their fundamental human rights have been infringed upon under the European Convention on Human Rights have a right to an effective remedy before the national courts. Interestingly, in the Ugenda Foundation case versus State of the Netherlands, the Dutch Supreme Court tried to qualify the ambit of Article 13 by stating that a remedy is effective if it will prevent or end the particular human right violation, and if that particular remedy offers some kind of adequate redress for a violation that has already occurred. And what this requires is that at the national level, courts must determine whether these rights and freedoms emanating either from the Constitution, for example, the 1999 Constitution, have been violated or not. Dr. Morocco-Clark earlier mentioned that legal disputes in relation to climate change are usually brought under the Nigerian law of torts or based on human rights law. And increasingly, over the past couple of years, and as you can see in Dr. Etemire's report, a lot of these legal disputes are rights-based litigation, which means they are brought under the human rights ambit. And under the Nigerian context, we see that there are two types of key remedies that are available to litigants in climate change cases. The first is pecuniary damages, and that is pecuniary reliefs, which is basically damages which could be special or general. And then you have injunctive reliefs or declarative reliefs. Now, in terms of damages, in cases like Chinda versus Shell, Ala Iru versus Shell, we see in those two cases that the courts in Chinda were not willing to grant award damages to the claimants because they had not successfully proven their case or proven the tort of negligence by the multinational corporations. In Ala Iru versus Shell, the court was willing to award damages, but was reluctant to award any kind of injunctive relief or compel the MNCs to stop oil pollution or gas flaring in those cases. Now, it's interesting that we see that in those cases, the courts are not willing to consider these injunctive reliefs and would rather award damages, especially in the Ala Iru case, the case of Ala Iru versus Shell, rather than an injunctive relief. And the reason why I'm drawing attention to this is because already in Section 34, subsection 2 of the Climate Change Act 2021 states that a court has that discretion to grant that order, to compel or stop the action of particular companies who are contributing to environmental degradation or contributing to climate change as a result of their actions. Dr. Morocco-Clark also earlier mentioned the plethora of laws that exist within the Nigerian environment, such as the Gas Flaring Regulations 2023, you have the Petroleum Industry Act 2021, and a host of others, just like Dr. Ekhator also mentioned. But we need to understand that it is only in the case of Etemire versus Shell in 2005 that we see the courts taking a proactive approach with regards to compelling the multinational company, which is Shell in that case, to stop gas flaring operations within that particular territory. So we need to understand that it is not enough, damages are not just enough to be awarded to litigants because they look at the financial benefits without looking at the long-term effects on the environment and on climate change generally. So what do we need to do? What is it that we need to consider when talking about remedies within the Nigerian context? The first thing we need to do is to consider is, should the courts have this discretionary power? Yes, they should have it because it has already been established by a plethora of procedural rules of courts and also by a plethora of legislations in Nigeria. Now, the question is, would we say that these remedies are sufficient and effective? To some extent, they are. So what do we need to do? Why do we see that in the case of Etemire versus Shell, for example, despite the fact that the Federal High Court had granted a perpetual injunction against Shell to stop further gas flaring operations in the area, reports, even after that judgment had been handed down, showed that Shell continued gas flaring operations. Does this mean that the MNCs are not carrying out a blatant disregard for the court judgment? Does it mean that they have no respect or regard for the law? These are the things we need to consider with regards to remedies for climate change litigation. So what do we need to do, and what is the way forward in ensuring that we have effective remedies for climate change litigation in Nigeria now and also in the future? The first is that litigants need to engage more with the justice system, and they need to be willing to look beyond just the financial nature, the compensatory nature of damages, and look at the long-term effects and the need to claim injunctive relief to compel these multinational corporations from continuing in the manner that they have already been doing for years. Now, another thing which Dr. Ekhator also mentioned when speaking about local standing is that litigants need to be aware that the more and the stronger scientific evidence they are able to prove in their case, in their climate change cases, the more the courts are willing to consider the strength of that evidence in exercising their discretion to grant injunctions against these multinational corporations. another thing that litigants should do is that they need to be aware of the financial implications, like I said, of gathering this scientific evidence, because it is not a walk in the park. A lot of financial work needs to be put into getting strong scientific evidence in this case. Now, what about Nigerian courts? What do they need to do? Whilst Dr. Ekhator mentioned the need for us to incorporate environmental education and climate change awareness into the curriculum of our students, both in the tertiary institutions, secondary institutions, and primary institutions. In the Nigerian courts, I think what we need to do is to have what we call capacity building for our Nigerian judges, from the High Court, Court of Appeal to Supreme Court. A lot of other MDAs like the MASA, Ministries of Environment have put in place various capacity building with regards to maritime law and a whole host of others. And I believe that there's a capacity for our judges to be trained and to understand what they need to know about climate consciousness and climate change litigation, especially what obtains in other African jurisdictions and in other regions like the European region, the North American region, etc. Judges also need to be innovative in their approaches, and they need to draw on jurisprudence from other African jurisdictions, and they need to consider the long-term consequences of their judicial decisions against the long-term effects of climate change and how this invariably impacts on human rights. And just to conclude, it's important to also ensure that states have a right to comply. They have that obligation to comply and ensure that MNCs comply with whatever court judgments or injunctions are given by the courts. The reason why we see that there is a whole lot of progress being made in other jurisdictions is the issue of compliance. That is what distinguishes these rights violations and effective remedies in other jurisdictions, the word compliance. Another key thing that we need to understand is increasingly we see that there is a shift in climate change litigation that is rights-based to one that requires the active participation of regional courts like the African Court on Human and People's Rights, especially as we see in the recent judgments of the European Court of Human Rights. And this particular judgment was handed down about 3 weeks ago on April 9th, 2024. And it was in the case of Vering, Schweiz, and others versus Switzerland. And it's a 2024 case. And Dr. Morocco-Clark already mentioned it before. And the court held that an EU state, for example, a country like Germany or Switzerland, can be said to have breached the provisions of the European Court or European Convention on Human Rights, I beg your pardon, as a result of failure to take appropriate action in relation to climate change. What this means is that the state can be held accountable under the provisions of regional conventions. And in this case, it would be the African Charter on Human and People's Rights, 1981. And so within the Nigerian environment, it is important for us to start considering how regional courts play a huge role, especially for litigants with regards to climate change litigation. I think this is a good place to stop. Thank you.
Yeah, thank you very much. Thank you very much, Dr. Irekpitan. Thank you for a very incisive presentation. I'll just go to a few questions. We are running to the end of the meeting right now. I just have a few questions, but any other person who has a question to ask can drop those questions on the chat, or you can raise your hands, and I think the admin will recognize you, and then we'll take your question. The first question that I'll ask, I think this will go to Dr. Ayodele Morocco-Clark, and then maybe if anyone has any perspective on it, they can also share their perspective on it. Normally, when conflict arises within the oil and gas sector in Nigeria, especially with communities and with individuals, that could potentially be a climate litigation, a climate matter. A lot of times, these cases don't go to court, or they go to court and then they stop and they move to private negotiation, especially for compensation and the likes. It's difficult to find negotiations where the parties are talking about the stoppage of polluting activities. It's usually about negotiation about how much compensation one can get, or the community can get from the company that is engaged in that polluting activity. What do you think? How do you see this impacting climate litigation in Nigeria? Because normally ADR, or alternative dispute resolution, is usually touted as a better option to litigation. But when ADR functions in this way in our climate, how do you think that impacts climate litigation in Nigeria? Good or bad? Can we move negotiation towards asking companies to stop polluting activities? Because presently that is not the norm in practice.
Yes, okay, thank you for your question. The thing is this, of course, we have to look at the socioeconomic reality in Nigeria. Sorry, can you hear me? Yeah. The reality is in Nigeria, and of course, with most of Nigerians living below the poverty line, the truth of the matter is survival comes before any other thing, before the protection of the environment for many people. It's the person who is alive and well that starts to think of protecting the environment. Where all is not well, then it's almost impossible for you to say they should put a premium on the environment. Nevertheless, if the people who are in the region, and mostly, of course, my talk has mostly been with the petroleum industry, but it's the same with the mining industry, manufacturing industry, and all. Those who are within those areas, you find out that those who are normally affected is like even abroad, the siting of some certain industries and businesses, activities are normally located in what is pretty much poor areas. And so, yes, those people are thinking of, oh, money, because that is what is going to solve their immediate basic needs. However, the idea of ADR, the alternative dispute resolution, is very important, but I would like the multi-door courthouse to be involved. So various states have multi-door courthouses, and this should be involved, even environmental protection, litigation, and all. I think there should be a system that says, oh, you first of all go to the multi-door courthouse. And one of the basic things that should form any agreement, even based on damages, compensation, or whatever you want to call it, is remediation and restoration. So whatever decision that happens, so even if you're coming to the multi-door, because if you go to multi-door and then you have environmental experts there, they look at what it is, and you have to make whoever is the polluter or the defaulter comply with the provisions of the law. You cannot be breaching the provisions of the law and then saying, oh, I just want to throw a few dollars at you. Because the truth of the matter is this: in Nigeria, the amount that is even paid in compensation is really, really, really small. And if you look at it vis-a-vis the operations in the West, over 10 years ago, almost 15, when I did my PhD thesis, I advocated immediately extraterritorial litigation, because the amount the people who suffer the pollution and have to deal with the climate change get here in Nigeria, it's a pittance. But when they go abroad, you see they hit them, and they hit them in foreign currency. So that when you extrapolate that to Nigerian currency, it's a bigger thing. And then you have to look at remediation. You look at the BP Horizon disaster and the way it was taken care. BP is a British company, but it happened in America. I mean, at that time, I was telling people I had shares in BP. My shares went down, and they hit them, and they've been paying, and I think they are probably still paying now, billions and billions of dollars. But the Niger Delta, one of the most polluted places on the planet Earth, is there, and these same oil companies are operating here, and you see the standards are different. So yes, ADR is a way forward, but I think it should be done in a formal way, as opposed to maybe the village chief that will just collect some money, or community leader, or the local government chairman, or the governor. That's my response.
Thank you very much. Thank you. Thank you. Does anyone have any response to that? I'll just ask one more question.
I'll just chip in. I think, to me, I think ADR is not the solution. It's not, because we need to hold them accountable. We say ADR is a solution in the context of we are negotiating. They'll be negotiating. If you go back to the Mosul crisis, go back to, I think in the mid-90s, there was a report about how to use ADR. ADR is being used in Niger Delta. We need a legal framework to hold MNCs accountable. ADR should be complementary and not a substitute, in my view. Because yes, we can use ADR customary law, but there has to be that framework that says if an MNC has done this, you can actually sue the CEO of that company for criminal responsibility and take them to go down, actually imprison them. We need some form of criminal sanctions, and the existing framework should be implemented, because ADR, to me, in the context of ADR for commercial issues, I think is very good. ADR in the context of Niger Delta ecocide crisis, I think is too little to hold MNCs accountable. Yes, as a complement, fine, but as a substitute, I don't think it should be a substitute. We need to hold them responsible ASAP. Thank you.
Just to Dr. Etemire, just to quickly jump in, if you don't mind, for less than 1 minute. I do not believe that there is a one-size-fits-all approach. I think both ADR and litigation can work side by side. And it also is also going to depend on the specific circumstances of each case. The reality is, how do you hold MNCs accountable when they know that they are just going to do payouts in form of damages and the problem still continues? And even when you have injunctions in the first place, you realize that more often than not, they tend to flout these injunctions and go ahead with the activity. So who do we hold accountable here? I believe it should be the state. The state has that protect, respect, remedy obligation, especially as it has been clearly expatiated under the United Nations Guiding Principles on Business and Human Rights. It might not be a binding document, but it's a document that almost all the countries in the UN are in complete unanimous agreement with. So I believe that once we have that consciousness, that states know that any attempt to suppress climate litigation cases that is seeking to entrench the human and fundamental human rights of these litigants, then it means that the states and these MNCs have failed in their obligations in the first place. Just my
So I think that the state needs to take up its responsibility in this seriously, because at the moment it appears as though socioeconomic issues in Nigeria, especially poverty, illiteracy, it's affecting the amount of these cases that even come to court. But a lot of times people settle one-on-one with the companies, and then, I was discussing with a friend, and while he was having this negotiation with this oil company about how they had polluted the environment of a client, and they were meeting, and he was trying to really hold them by the jugular. The client had gone behind to accept something from the company, and he was left he was left standing in the middle without anything, Yeah, thank you very much. The next question I have is on Section 34 of the Climate Change Act. The Act provides for climate change obligations on private and public entities. It even says there that I think some MDAs should ensure that climate change studies should be mainstreamed into the curriculum of various programs in Nigerian universities. And Section 34 says that anyone who breaches any provision in this particular act has committed an offense, and that person would be liable to such punishment as the Commission will hereafter specify in a regulation. Now, it's been 3 years since we had that act, and I don't know if anyone has any current information as to whether they have produced a regulation specifying a punishment yet. But that means that even though the act provides that opportunity, it appears as though the Commission, the Climate Change Commission or Council in Nigeria, they have not done what they are supposed to do to give the act its teeth in order to be useful as a litigation tool. Looking at administration in Nigeria and all of that, does anyone have any perspective on this? I hope they are not being lobbied by the oil and gas companies to sit behind as the case were or whatever. But this has been 3 years already.
I think just
I'm
to
not
chip
aware
in.
of this.
Okay, sorry.
No, go Eghosa, go.
I was just thinking, what are the NGOs doing really? I think there's a massive gap with the NGO sector. I think, because remember what SERAP is doing in terms of the litigation by SERAP, I think there should be a niche NGO trying to hold government accountable. Because most times, I think there's a massive gap in the NGO consciousness. Yes, I know ERA is doing amazing stuff, etc., but it's all about litigation. It's all about taking them to court. In terms of the advocacy aspect, there appears to be, this is just for me as an outsider, there appears a disconnect between what the NGOs, in my view, are doing and what the Commission is doing. I think it's the NGOs really and other relevant stakeholders that can actually hold the Commission to account, and there should be public interest litigation as well. Lawyers should sue the government, should take them to court and ensure that they actually implement these provisions. I remember this privacy case that just took place that there's a Nigerian academic who owns the privacy institute that took the Nigerian government to the ECOWAS court. They got a favor of, in terms of the Cyber Crimes Act, they got the judgment in favor of the NGO, and the government actually changed the law in that regard. So in terms of what environmental NGOs are doing, I think we need to have more engagement as academics with the NGOs on the ground. There appears to be a disconnect. That's just my perspective.
Thank you.
Well, I'm of the opinion that the thing is, everybody keeps saying we need to enact laws, we need to enact laws, we need to do this. But the reality of the fact is the laws that we have are not being properly, implemented. So issues of enforcement and compliance are massive. We're talking of judgments of court, you take someone to court. In the Bemre case, once the Federal High Court issued its judgment, a government spokesperson, Emmanuel Agbegi, on behalf of the Petroleum Minister, came and said they were not going to obey it. So the problem in Nigeria is not only, we have lax laws, because when the laws are there, the EIA is there, how many people are doing it the right way? The Climate Change Act has been there for the past 3 years. What have we seen done? The truth of the matter is this: the rule of law is in chaos here right now in Nigeria, whether we agree or not. So I don't think the answer is just only, enact more laws and enact more laws, because enacting the laws, the enforcement, the regulators are not being, the NOSDRA that is in charge of the oil industry. When oil spills happen, they rely on these oil industries to use their boats and their equipment. They put them up in hotels and all. What kind of a regulator is that? Nigeria is not living up to its responsibilities. How can you not empower a regulator and say they should be in bed and cahoot with the people who are causing the havoc that they're supposed to be regulated? These are the problems. We need to get it right. We need to get the proper people for the job and also put money where it matters. Because the oil industry is the goose that lays the golden egg. I don't know why money cannot be invested in the proper regulation of that industry.
Thank you very much. Yeah, someone just asked in the comment section a while ago that what happens when the government fails to comply with its own laws or even with court orders, I guess. Is it a helpless situation? Can supranational courts help extraterritorial courts here?
Well, let me just take this. So in other jurisdictions, when states fail to comply, with certain climate change obligations, they are compelled, right, by the court to make sure that they put in place, that they give them a timeline within which to put certain climate change targets in place and ensure that they meet it. And then they write reminders, right, to the government to say, you still haven't met this. This is your timeline. Now, when that happens here in Nigeria, the question is, after the judgment, everyone goes to sleep. It's almost like the laws are there. We have a lot of laws just lying around, but they are paper tigers because enforcement is the problem. So we need to have some kind of follow-up mechanisms. And like Dr. Eghosa and Dr. Ayodele have already said, the NGOs, right, and other public interest lawyers need to step in and compel the government, because we have the power of social media now. And so a lot of the more information we draw to issues relating to climate change and what each particular state and non-state actor should do, then I think there will be a change in making sure that states comply with these judgments.
Thank you very much. Thank you very much for your contributions and for your presentations and for trying to attempt to provide them some form of answers to these questions. I'll just hand over now to Dr. Ivano so that he can give us a closing remark, some reminders, and wrap this all up for us. Yeah. So Dr. Ivano, please.
Yeah, good afternoon, everyone. Thank you very much, Uzuazo, and all these great speakers for this session. I'm really proud of what has been done by the Nigerian group with the national reports, which we invite you to read. All the attendees, please give a glance to the report because it's really well done. And I mean, there are so many remarks I would like to do, but I realize that we're already at the end of it. So I would just like to thank everyone that participated to the project and these wonderful speakers to restitute really a picture of what we are doing in this moment, what has been done in Nigeria, what are the possibilities. I saw some interesting, more optimistic, some other pessimistic comments about the situation on corporate climate litigation in Nigeria. I think we are still at the inception of this kind of field. That's why I believe the collaboration that we started last year and that we are continuing this year with Uzuazo and this great team of experts could be really helpful to improve also our knowledge on this kind of topic. We would like really to involve as much as possible, not only the academics, which you have heard that are great, and the practitioner, but also judges, scientists, economists, people that could be the real stakeholders in this kind of litigation. So I would like just to repeat what Anthony said at the beginning. We are going to host in 1 month, on the 20th and 21st of June, the African Summit, which will be in Kenya, in Nairobi. And we would like to invite you to participate. Again, it's going to be hybrid. So if you're not in Nairobi, of course, you can participate online. And the idea is to, in a way, continue this discussion to try and involve as much people as possible. You heard from our speakers also some examples from other legal orders, from other legal systems. This is really fundamental in what we are doing. We really need to collaborate. We really need to discuss about the possibilities that are out there, as was absolutely rightly said by Ayodele and by the others. We have a problem of enforcement, and not just in Nigeria, in most of the countries. And that's why we have to understand how to use what we have to improve our climate governance. So thank you very much, everyone. Please stay in touch with us. Please follow the work of this great group of Nigerian speakers and experts, and follow our BIICL work. And yeah, please give a glance also to our global toolbox on corporate climate litigation. Thank you again to everyone that attend this conference. And bye-bye. So thank you again, Uzuazo.
Thank you.
Thank you very much.
Thanks for having us.
Thank you.
And thanks for all who attended.
Have a great afternoon.
Thank you.
Thanks to all who attended.
Thank you.
Right.
Bye.
Bye, everybody. Thanks for.
All right.
Bye.